Thank you for your kindness to be here a little bit earlier. So now we will listen to a report on the independence of the judiciary and access to justice, because it's going together. You have the floor.
Thank you very much, Ms. President of the Court, honorable judges, participants. Let me first of all thank the Turkey Tribunal for having given to me this opportunity to be a reporter for the Court. And I should also warmly thank the Association of Judges, the European Association of Judges, and its president, José Grea Matos, and another important European Association of Judges, MEDEL, and its president, Philippe Marques, who should be connected just now via internet, because they supported me in drafting the report, and the report has been finally endorsed by the two associations that represent thousands of judges in Europe. I'm a serving judge, and I've been independent expert of the European Union for almost 8 years. In between 2007 and 2015 in Turkey, I've been also independent expert of the Council of Europe for specific mission targeting the Constitutional Court. My expertise was in the context of the negotiation for the accession of the European Union, of Turkey to the European Union. And namely in the annual or almost annual peer review organized by the European Union in view of the annual progress report about Turkey. So I had the opportunity to visit Turkey many times. I had the opportunity to interview many people, from the stakeholders to the normal people from the civil society or from the association. And I drafted several reports which have been commented by the authorities in Turkey, by the Ministry of Justice, and then they have been published both by the European Union, and still are visible in the website of the delegation of European Union in Turkey, and by the Ministry of Justice. So some sources of my report have been collected directly by myself, but this was until 2015. So my last mission was in May 2015, and it was in Diyarbakir, exactly. We have just heard about Diyarbakir. For the first time was a different topic. It was visa liberalization, because at that time the negotiation had already been suspended because of the problem related to the rule of law in Turkey. But still there was an interest in pushing the visa liberalization process. And the mission was organized because 2 months before, in March 2015, the Parliament passed a so-called security package. And it was a time of elections. There was a first round of election. A few weeks later, our visit in Diyarbakir, and there was also a bomb killing many people before the elections in Diyarbakir. And after that election, in June, it was not possible to form a political majority in Turkey, also because the pro-Kurdish party, the HDP, got unexpectedly, I think, for the political majority, a 13% of vote. And that changed the perspective of the political majority at that time. So a new round of election was organized in November. But what I can witness myself is that when we arrived in Diyarbakir in May 2015, the city was already disseminated by armored cars, was basically militarized. And it was also unexpected what happened to us, because for the first time it was an official mission organized by the European Commission in cooperation with the government of Turkey. There was not any delegation waiting for us at the airport of Diyarbakir. This is just to introduce the context and to see another point. So justice is in every report that has been brought in front of you, and all the witnesses that have come in front of you, they have a common request, which is a claim for justice, for a fair trial, for an independent tribunal. So justice embraces all the reports and all the witnesses that we have in this trial. However, we should not undervalue the issue of Kurds that we have listened to many times. And just a few minutes ago, this was not prepared for my presentation, but this testimony about the Newroz, the spring festivity of the Kurds, this is a usual occasion in which Kurds are arrested. I mean, there have occurred mass arrests for years in Turkey, and it is reported in many reports of NGOs and also official reports of institutions and organizations monitoring Turkey. And they have been arrested by the same legislation, which is the anti-terrorism legislation, that after the coup d'etat has been used against the Gülenists, if they exist really, and the civil society. So what is happening now to the judges, the prosecutors, the teachers, the journalists, happened for a long time before in relation to the courts. This is exactly the same legislation. The propaganda that has been mentioned yesterday by Meltem Aktay, and the other criminal offenses. So I think that for the court would be important, it is not part of my report, but if you want, we can elaborate a bit later on. Important to know this framework, which is common to this period, which is the anti-terror law and the special anti-terror criminal law that date back in 80s, 83, the State Security Court were created in 83, and then they went also under the scrutiny of the Court of Human Rights in an important judgment, which is known as the name of the claimant, which is Inkal against Turkey. So after this long introduction, so my report is aimed at answering two questions. The first one is about the compliance of the independence of the judicial system with the international standards. So the first part of the report is about independence. And the second part is about access to justice and effective judicial protection. And of course, if the reply to the first question, that there is no an independent judiciary, affects the second one, at least for what regards the effective judicial protection. However, also in this second part, is it possible to enlarge a bit our consideration? I will go rather quickly, if I can, through my report in order to give you the structure of the report, which is rather large and probably not sufficient to tackle all the relevant issues about justice in Turkey. And let me just try to highlight the time frame of the report. So in my consideration, I start from 2010, when important constitutional reforms were adopted in Turkey that reinforced the independence of the judiciary and the protection of fundamental rights. Turkey became a candidate country for the accession to European Union in 1999. It was December 1999. In October 2005, the negotiation for the accession started, and also the negotiation for the Chapter 23, which is judiciary fundamental rights, and my mission together with the opening of this chapter. Between 2007, 6 and 7 and 2012, it was a good period of reforms in Turkey. There was a significant change in the direction of the protection of fundamental rights. 4 different packages of judicial reforms have been passed by the parliament along those years. And the constitutional reforms of 2010 are the landing constitutional level of the reforms that I've shortly mentioned to you. And especially the third package, the fourth package of judicial reforms adopted in 2013 was aimed at aligning the practice of judges and prosecutors to the case law of the Court of Human Rights that, as we have heard during the previous reports, has convicted many times Turkey because of violation of fundamental rights. However, unexpectedly, at least for the observer, in 2013, there was an irreversible turning point for the protection of human rights. In 2013, 2 events occurred. The first event was in May 2013. It has been mentioned also today, and is related to the so-called Gezi Park protest, a wave of civil demonstration began in Istanbul, initially to contest the urban development plan for the Gezi Park, a little park in the European part of Istanbul. And they were peaceful demonstrations that were repressed violently by the police. This is reported in official report also of the Commissioner of Human Rights of the Council of Europe. And the reaction of police triggered the reaction of the civil society. 2.5 million people took the street in that protest along the country. Looking for what? Claiming for what? For the respect of the fundamental rights, the freedom of expression, the freedom of press, the freedom of assembly that were put at risk by a government that was adopting progressively restriction to those rights. The consequence was what? The consequence was violence, in the sense that, according to this report of the Commissioner of Human Rights, the outcome was 6 people died, more than 8,000 demonstrators in 13 provinces had sought medical attention, with 63 serious injuries, 3 of which were in critical condition, more than 100 cases of head trauma, 11 persons losing an eye, and this was the reaction of the police, according to the report of the Commissioner of Human Rights. What is the further outcome of this situation? Impunity. In the sense we don't have a record of cases of punishment of the police after this event. We know that participants in the demonstration, or people who are supposed to be organizers of the demonstration, have been investigated for different title of crimes by the police and the prosecutors. The second important event is here on the screen is December 2013. December 2013, there was an investigation in a corruption probe that involved the government directly. The sons of 3 members of the cabinet were arrested. 4 ministers had to resign. Even the daughter of the president was under investigation. Many important representatives of business community. And this brought to the arrest of 3 sons of cabinet minister and 34 others. The reaction was violent in institutional terms. We will see later on what I mean about this reaction. But what is important to highlight is already in July 2000 and in April 2017, there is this statement issued by the Parliamentary Assembly of the Council of Europe about the coup d'etat that occurred 3 years later on. The statement is the following, is important. Considering the scale of the operation undertaken, the Assembly is concerned that the state of emergency has been used not only to remove those involved in the coup from the state institution, but also to silence any critical voices and create a climate of fear among ordinary citizens, academics, independent non-government organizations, and the media, jeopardizing the foundation of a democratic society. This fear, especially among judges and prosecutors, was spread before July 2016. So the facts of July 2016, the reaction of the government is rooted in facts that occurred before. When we speak about international standards of independence, we can mention a lot of sources to justify the statement which are contained in the report. Let me just mention 2 decisions issued on one side by the Court of Human Rights and on the other side by the European Court of Justice. In the first one, the judicial independence is defined by the Court of Human Rights in the following way. We have to look at the manner of appointment of the members of the judiciary, the duration of the term of office, the existence of guarantees against and outside pressure, and the question whether the body presents an appearance of independence. In 2018, for the first time, the Court of Justice of the European Union affirmed that the principle of rule of law is subject to the decision of the court. And it was this famous ruling about the Association of Portuguese Judges, in which, since the effective remedy is included in the Treaty of the European Union, Article 19, the court said that judicial independence is an essential component of the right on an effective remedy in situations where rights and freedom are violated. Why I'm telling this? Because the aim of my report is to show that in Turkey, all principles related to standards of the independence collapsed after July 2016. And I'm referring here to the principle of external independence of the judiciary, the internal independence in its 4 features: individual independence from internal and external pressure, individual independence from internal hierarchies, the principle of natural judge, the free right of association, the appearance of impartiality, the autonomy and independence of the Council of Judges and Prosecutors, and the aspects highlighted in the decision of the Court of Human Rights: independence of the judiciary of the executive, the tenure of office, the manner of appointment of judges, and the appearance of independence, are the most problematic in this respect. Speaking about the reforms of 2010, very shortly, it was a significant constitutional change in the Constitution that was approved by a referendum after that, and the referendum got a large majority of approval. And it regarded justice under 2 items. The first one was the Constitutional Court. The Constitutional Court were given a new power, which is an internal remedy, an individual application, similar to the one which is used in front of the Court of Human Rights for the protection of fundamental rights, and similar remedies exist in other European countries, for example, Germany or in Spain, recurso de amparo. So the aim was to create an internal effective remedy, also for preventing some cases to flow to the Court of Human Rights. I had the opportunity to coordinate a mission that published a report in 2014, a need assessment report for the Council of Europe that was also presented in front of the Court of Human Rights, the president of the court in Strasbourg. So this court, after September 2012, when the remedy started to become operational, proved to be very effective. I've mentioned in my report, I cannot go through the cases that are rather complicated, but just 3 cases here: Twitter ban, Balbai ruling, and Can Dündar and Erdogul case. Twitter ban, Twitter was closed by the government, and the social media had an important role in the Gezi protest, and the Constitutional Court reopened Twitter, and the decision had been executed by the government, slammed by the government, but executed. Balbai was a very important secular journalist of Turkey that have been convicted to many years of detention, many years, and he was elected in the parliament. And again, in connection to the right to be a member of the parliament, he was made free by the Constitutional Court. In the case of Can Dündar and Erdogul, even more complicated, because it happened in May 2015 that they published an information about a fact. The fact was that the Adana prosecution office stopped, searched, and seized a truck that was bringing arms allegedly to Syria, allegedly to ISIS. And this truck allegedly belonged to the secret services of Turkey. The prosecutor and the policemen were after that arrested, detained, and convicted. But also the journalists that simply conveyed the news to the general public had been arrested for many days until the Constitutional Court made them free. After that, Can Dündar has been convicted to a very long detention and now is a refugee in Europe. And the second important constitutional change related to the High Judicial Council. The High Judicial Council before 2010 was composed by 7 members appointed by the judicial hierarchies. And it was even physically located in the Ministry of Justice. So there was a clear confusion between judiciary and government up to that. This was a very important reform because according to this article of the Constitution, the 22 members, not 7, among 22 members, 15 members were judicial members elected by peers, and even 7 by the first instance judges. So this model is fully in compliance with the recommendation of the Council of Ministers of the Council of Europe, which recommends that at least the majority of judicial members, be judicial members, and that the judicial members are elected by peers. This brought pluralism in the Judicial Council, and judges started to feel their own independence because they were protected externally and internally by an independent judicial council. A proof of that I found during my mission in the behavior of some judges that used to resist to the decision of Yargitai to the Court of Cassation when the Court of Cassation quashed and sent back to them the decision. Another proof is the investigation of 2013, when the prosecutor started to investigate the government. And I mean, in my country, we have a long tradition of public prosecutor investigating the government if there is a possible criminal offense. What was the reaction then? The reaction by the government immediate was that this amendment to the bylaw of the judicial police, according to which the police should report first to the superior and then to the prosecutor. We have never had in Turkey a functional judicial police depending on the prosecutor, which is a separate problem. However, this was about reporting. Many police officers were immediately transferred. Some were sacked by the government. And at the same time, since the High Judicial Council, majority of members, 13 of members, decided to issue a statement to protect, to defend the independence of prosecutors, there was also a reaction regarding the council. The reaction was what? That first of all, the parliament adopted a law that increased dramatically the control of the government over the council. I cannot elaborate further now because it's a bit complex. If we want, we can come back during the next session. Then there was this legislation adopted in March that abolished suddenly these special courts, which have a long story, very controversial story. This abolition was welcomed by the civil society because of the criticism that always accompanied this court. But which is the problem with this situation? That judges and prosecutors have been transferred in few days, even without being consulted. New judges and prosecutors have been appointed, even not being consulted. And the cases, the most important cases, also those cases related to the investigation against the government, passed to new judges and to new prosecutors. And this is not in compliance with the standard of independence, both the fact that the judges are moved without the consent and the fact that the standard of independence also covers the principle of the natural judge. In the following years, in between 2014 and 16, but especially in 2014, thousands of judges were forcibly moved to other destinations. As you can understand, it is not the same working as a judge in Ankara or in Diyarbakir and change your life in few days, as it happened during that period of time in Turkey. Then the arrest of judges started. So the detention of judges who were performing the work started before July 2016. Here are mentioned two cases that I cannot explain further. What was the accusation against the judges? The accusation was the same that we see today for the Kurds, for the Gülenists, also before. It was the anti-terror law. The anti-terror law impinges on the criminal code. Article 314 is in the criminal code. Article 220, which is another key provision, is in the criminal law. The anti-terror law that was adopted during the 90s increases the penalty. But the problem is in the criminal code, not in the anti-terror law. It increases the penalty by half. So, for example, in cases that have been mentioned also by the journalist yesterday, in case of membership in an armed organization, the maximum penalty is 15 years, but increased by half, it becomes 22.5 years. It was the case of the journalist convicted to 22.5 years to detention. But there is a provision which is very tricky. In Article 220, it says that it can be punished not only the membership in the organization, but also those who commit a criminal offense on behalf of the organization, or those who aid or abet the organization. So they are not members, but they are punished as they were members because the criminal offense is considered to be committed on behalf of the organization. Example, wearing a flag of the PKK in a demonstration that can be a criminal offense against the law on demonstration on behalf of the criminal organization. Throwing a stone during the Nevros festivity, firing a tire, that can be considered a criminal offense committed on behalf of an organization or aimed at aiming and abetting the organization. In only in 2018, according to the Commission of Human Rights of the Council of Europe, there have been more than 40,000 convictions because of the anti-terror law, more than 40,000 convictions. And in this famous case that has been recently terminated by the Grand Chamber of the Court of Human Rights regarding Célétine Demirtas, who was the co-chair of the HD party, which is in prison since November 2016, the court has also established that this article of the criminal code, because this is not the anti-terror law, but this is a criminal code, an empty article. There is no content about the substance of the offense. So it's not possible for the people to understand what conduct is going to be criminalized by the prosecutors and the judge at the end of the trial. After July 2015, we have seen something probably never seen before in the world. I mean, such a number of judges and prosecutors arrested and dismissed. And the state of emergency was declared and for 2 years. That means emergency decrees issued by the government having the force of law. That brought also permanent changes to the legislation. And here, looking at the monitoring committee of the Council of Europe report, what happened? It happened that on 16th of July, the following day, the High Council of Judges and Prosecutors held an extraordinary meeting and decided to lay off 2,745 judges, remove 5 members of the council. 2 members of the Constitutional Court have been arrested immediately after, on 16 July. Arslan Altan was a member of the Venice Commission of the Council of Europe, and then the dismissal of members of the judiciary. Try to compile a list of 2,745 names. It takes days. It takes days. And this list was ready the day after the coup d'etat. And in the list, they were included also judges who had died before, some months before. They were already in this list. After the list, the arrest, this is Arslan Altan, this is another case of the Court of Human Rights that I had the opportunity to meet many times because it was my counterpart in this project of the Council of Europe. And then detention of thousands of judges. Some fled, some are refugees in Europe. There are some refugee judges also here, at least 2 or 3. I see hands raising here. That means that in Europe it has been recognized that judges are persecuted, because in order to get the refugee status, a person has to be persecuted by its own country. And by the way, if we look at the statistic of the European Asylum Support Office, Turkey is among the 10 countries with most application for asylum in the member states of European Union, country of origin. So that gives you the size of at least the alleged persecution in Turkey. Why judges were arrested? This is a list of questions that the prosecutor had in his or her hands, collected by Human Rights Watch. For example, which high school and private school did you go? Were you encouraged to vote for not to vote for the AKP during the election? Which candidates did you support in the High Council of Judges and Prosecutors election of 2014? This is a key issue, the elections of 2014. I cannot elaborate further, but it is a key point. And if you look at the consequences, former 5 members, current 5 members at the time of the Judicial Council had been detained, 8 previous members of the High Council, and 16, all of them, election candidates in the independent list which ran for the election of 2014. All of them have been detained after the coup d'etat of July 2016. Not only Gülenists, because this Václav Havel Prize, Murat Arslan, the president of Association of Judges, YARSA, that is association associated to the 2 most important associations of judges of Europe, he was arrested probably because he was the president of the association, the same charge, terrorism, and then convicted to 10 years in jail. Currently, he's in jail in Turkey, and he is 2007 Václav Havel Human Rights winner, awarded by the Council of Europe. Then, ill treatment of judges. These are two judges who died in prison. Another judge, unfortunately, died some days ago in a camp in Germany, trying to flee from Turkey. And the association has been liquidated, dismissed. YARSA has been dismissed. The other association of judges, the Judges Union, has been dismissed. At the same time, another association of judges have been set up. In an official declaration, it has been admitted by the government, and now it is the Association of Judges which collects more than 10,000 judges in Turkey. It was set up in view of the election of 2014. In 2016, the European the network for the Council of the Judiciary suspended the High Council of Justice from the network because it does not comply with the rule of law rules of the network. This is probably the most important political step up to now, in the sense that on 25 April 2017, the Council of Europe, the Parliamentary Assembly of the Council of Europe, has downgraded Turkey to the monitoring status. It's the first time, I think, in the history of the Council of Europe that a country is downgraded to a monitoring status because of the situation of the rule of law. The almost final step is 2007 constitutional reforms that then were approved by a very controversial referendum. If you remember, there was a very, very little majority and also allegation of irregularities. And the Council of Justice has been brought under the political control, in the sense that 6 members are appointed by the president and the rest are appointed by the parliament. There are no members appointed by the peers anymore. But nevertheless, even after the state of emergency was closed, the High Judicial Council continued to transfer forcibly judges. In 2019, more than 4,000 judges have been forcibly transferred in Turkey, even though, as I know, in the strategy that they were preparing at that time, they wanted to comply with the recommendation of not transferring forcibly judges and prosecutors. And this is really the final step. Judges in July 2016 were around 40,500. 4,500 were dismissed, but now there are almost 20,000, so 10,000 judges recruited in few years. I've been one of the directors of the Italian School for the Judiciary. We trained the new judges, and for us it took at least 18 months to train decently some hundreds of judges. I cannot imagine how is it possible to train 10,000 of professional judges in 2-3 years and to have them ready for this trial. 10,000s of cases regarding criminal organizations. And very shortly on the part 2, because I don't want to bore you, honorable judges, about the effectiveness. So my conclusion about independence is not positive. You have the conclusion in the report. This affects also the effectiveness. However, we should also consider, and these are chapters of my report, the role of lawyers and human defenders, the right of defense, the fairness of the procedure, the fact that the ruling of the European Court of Human Rights are not enforced, and also the fragmentation and weakness of other public institutions responsible for protecting human rights. As regards the lawyers and human rights defenders, they paid a very high price. You have the number here. Let me just remember Ebru Timkit is the lady on the right side on the screen who died in the prison after 230 days into hunger strike. And according to friends, she only weighed 30 kilograms when she was brought to the hospital together with the male colleague, Aita Kunsal, at that time. And also the president, the chief and the director of Amnesty International, They have been arrested, detained, and then convicted. But the same destiny for many important NGOs in Turkey. And if you look at my report, I have devoted single chapters to this issue that I cannot resume today. So obstacles to the defense, especially in anti-terror cases, coming from law and practice. Lack of evidence supporting detention. This is a long story for Turkey, especially for pre-trial detention. The disruption of the right to a fair public trial, the misuse of pre-trial detention. And there are chapters also in relation to the fact that the decisions are not enforced. The rulings are not enforced. The ruling of the national courts are not enforced. Many people have been released and then rearrested immediately, especially journalists or people who are visible, also important cases. They are immediately rearrested by another judge, by another prosecutor. And decision of the Constitutional Court, this decision that are mentioned here, has not been enforced. And the decision of the Court of Human Rights are not enforced. We have, and I'm closing, two important cases decided recently by the Grand Chamber. There have been some decision that brought to the final decision by the Grand Chamber. One is Selahattin Demirtas, the co-chair of the HDP, and the other one is Osman Kavala, another person that I had the opportunity to meet as a representative of the civil society, a philanthropist. The first is in jail since November 2016, the second since November 2017. The second has been acquitted twice, but another charge has come after the second acquittal. There is always a new charge. And they are still in detention. And despite of the fact that the Court of Human Rights, by a final decision, has ascertained that there has been violation of fundamental rights, Article 5, Article 18 of the Convention, they are still in detention. And this is the declaration issued by the Ministry of Interior after the Grand Chamber regarding Selahattin Demirtas. The European Court of Human Rights ruling, whatever the reason, is meaningless. And recently, in the last week or 10 days ago, the Council of Europe, which is monitoring the process of enforcement of the decision of the Court of Human Rights, gave a final deadline, which is before the end of the year in the two cases, for the court, for Turkey to comply with the decision of the court. And also for this part, unfortunately, in my report, the conclusion to the question is rather negative. You will probably have the opportunity to read it. But I've not found any positive sign in the last years to have real hopes for the access to justice and effective judicial protection of fundamental rights. Thank you for your attention.
Thank you very much, Mr. Luca Perilli, for this excellent report. Very interesting, a little bit discouraging. So now we are going to put some questions to you by the judges. Judge Bianco, would you like to start?
Thank you, Madam President. And first of all, my thanks to Judge Perilli for the excellent report, the written one, and also for the presentation today. I have a few questions, and I would like to know your opinion, your insight about the situation in Turkey that, as we learned, you know quite well from your numerous visits in Turkey. The first question is, until 2013, you are saying that there were some positive reforms going on, and the position of the High Council of Justice was rather in conformity with the European standards, especially with the Magna Carta of Judges and etc. How can it be explained that immediately after the Gezi protest and the corruption case, it was the High Council of Justice who changed its attitude and did not continue to behave in protecting transfers of judges, removal of judges, and etc., but abided immediately to the government? Was there a lack of kind of perception of independence, structural problems, lack of guarantees for the council? What was the the reason behind this entire shift, because then we see later the legislative changes and etc. So this is my first question. Do you want that I ask the other questions, or one by one?
As you wish.
So please, if you can.
Okay, if you don't mind, I will consult some notes. I have my reports here with me. So what happened after December 2013? It happened that the Minister of Justice resigned, and he was replaced by another Minister of Justice and by another Undersecretary. Why this is important? Because this reform, this constitutional reform, which was a good reform, was not perfect, I would say, in the sense that in the council, the government was represented by the minister and by the undersecretary. And the minister was the president of the council. And the undersecretary was the president of the first commission, the commission that was in charge with the appointment of judges and prosecutors. And therefore, when the new minister was appointed, the president changed and the undersecretary changed. And immediately after, it was in the first session that with the new minister, 15 January 2014, there was a new item to the agenda of the day that was reshuffling the composition of the first commission. That was the commission dealing with the appointment. So the president of the commission was the new undersecretary. So one was changed by the government. And then other two members were changed. These members are the Professor Bülent Çiçekli, that currently is in Europe. He fled after that. And Ahmet Berberoglu, that was elected in 2014. He got a lot of votes. But then it has been sentenced to 12 years and 9 months of detention. And this changed the majority of the chamber. What we can say, fear, a different orientation. But since 3 members of the chamber changed, from that point, the council started to transfer judges and prosecutors. But it is not only that, because as I said, there was a law enacted immediately after, in February 2014. It is the law number 6524. This law brought significant changes to the council. Those changes have been declared against the Constitution by the Constitutional Court on April 10, 2014. But the decision of the Constitutional Court have not retroactive effect. So what was done at that point. And it was this Constitutional Court that was operating in the interest of the protection of fundamental rights. They are different items, rather complicated. If you want, I can go through the different changes brought by the law. Very, very, very simply, I try to keep it simple. It was given to the Minister of Justice the power to appoint the president and the vice president of the inspection board. One of the most important reforms made along the constitutional reforms was moving the inspectorate service from the Minister of Justice to the Judicial Council. Because let's say that this inspectorate service was perceived like a sort of chain between the government and the judges in the different regions of Turkey. I had the opportunity to participate in a conference regarding the inspectorate service in 2007. I have to tell you that all the representatives in that room, there were hundreds of people, they were only men. And also it was a bit astonishing for me looking that the members of the inspection service in a judiciary which is composed now probably for the majority by women were only men. It has been brought again under the control of the Minister of Justice. The Minister of Justice now is the one who performed the investigations about judges and prosecutors, disciplinary offenses, evaluation, because this is the inspection service. Further, it was given to the Minister of Justice the power to determine in what chamber the members would serve. So it was made legal. What happened informally before was transformed in a legal power by the legislation. The Minister of Justice could appoint the whole administrative staff of the Judicial Council, the reporters, the Deputy Secretary General, And the law established that the current members of the staff should terminate immediately the task. So the whole staff on what the members of the council relied for everything was then appointed by the Minister of Justice. And then it was even given to the Minister of Justice a power regarding the disciplinary investigation against the members of the council. And this law has been declared unconstitutional, but then the change in the staff, in the chamber, already occurred. And this is the climate that brought to the election of October 2014.
Okay. Thank you very much. My second question is, somehow you hinted it when you referred to the fact that the Parliamentary Assembly of the Council of Europe has restored Turkey into the monitoring system in 2017. Considering your experience in Turkey, do you think there is room for international organizations, EU, Council of Europe, OSCE, or EU member states to take action, political or even procedural action, in relation to Turkey in order to improve the situation?
So thank you very much for the question. I mean, I'm a bit embarrassed in answering this question, being a judge. I mean, I'm not a politician, and for me it's difficult to reply. But I will try to give a legal answer, if possible. So when in 2005, first in 1999, Turkey got the candidate status to access European Union, and then in 2005, the negotiations were opened. You know that, you perfectly know, sorry for that, you know much better than me, that there is this unanimity rule. In order to open the negotiation, every single chapter, all the countries of European Union have to agree. But a precondition are the Copenhagen criteria that were adopted by the European Union, by the Council of European Union in Copenhagen in 1993. One of the criteria is rule of law. Therefore, there was the prospect at that time that rule of law would have been respected in order to support the process of negotiations. Now we see what? We see a country in which the rule of law has been dissolved along the years. There was a good progression. There were very good progress until 2013. In the last 7-8 years, it's a dissolution, even of what existed before. And in legal terms, my question to myself is, if we have a treaty, which is a legally binding instrument, the Treaty of Stabilization and Association, the pre-accession treaty, which are grounded on rule of law, and one of the parties seriously breaches the treaty, my question to myself is, what is the legal consequence of breaching a treaty? Because nowadays I don't see any consequence, because the negotiations are suspended but not terminated. And this is what I ask myself in terms of having been for a long time an expert of European Union investing in this field. And the second is, but I don't want to elaborate much on this, is about the Court of Human Rights. So the Court of Human Rights, because Turkey is a member of the Council of Europe since 1949. And in the Court of Human Rights has been invested by thousands of files coming from Turkey. And the first decision have been adopted after some years. And in some cases, the court said, according to its doctrine, that first, the internal remedy should be exhausted. The question that I have always made myself is, could be considered the Constitutional Court an internal remedy after that the Vice President and another judge were immediately arrested the day after the coup d'etat? Was still, this is, I don't have a clear answer, but this is something that I have asked myself for a long time. For the rest, I'm not in the position to reply to your question. I apologize for that.
And the answer to this question brings me to the following question. Is the Turkish Constitutional Court, you are referring to the arrest, I'm referring to something else, to the case of Mehmet Alpay versus Turkey. where the district court was able to avoid the enforcement of the decision of the Turkish Constitutional Court. So my question is, under these conditions, can we say that the appeal before the Turkish Constitutional Court is an effective remedy? Does it have any sense anymore? I mean, the reform of 2010.
Sorry, yes, I don't think I can answer this question. Okay. I think that it will be answered soon by the Court of Human Rights, and it will be much more credible than my reply today.
Now, in a way, it is in the concurring opinion of the court in March 2018 in that case, Alpay versus Turkey. So it obliged 6 judges to write a concurring opinion, which is rather unusual. And therefore, my last question. Do you think in this situation that Turkish judiciary is able to provide an effective remedy for cases of torture, abduction, killings, violation of press freedom, so basic guarantees, basic human rights guaranteed by the Convention or European Convention of Human Rights or other international documents? An overall assessment, please.
So, thank you for this question. So, how would it be possible, in principle, for a judge to ensure effective judicial protection? So, he would need independence, internal and external, and professional capacity. These are the 2 main requirements for a judge to enforce the rights. And in these cases that you have mentioned, the counterpart is the state. And we have to admit, there are judges here, that in Turkey, there has always been this attitude of the judges to protect the state instead of the individual rights of the citizens. So the Kurdish situation is a clear example of that. I even think that some judges that have been detained and dismissed, they might be, in the past, use the same legislation to punish the Kurdish. So in order to do that against the state, you need a strong independence and a strong professional capacity. Regarding the independence, we have seen the overall situation of Turkey. It is not really encouraging. For what regards the professional capacity, please consider that in the system that they have in Turkey, the judges and prosecutors are recruited by the Ministry of Justice, even not by the Judicial Council. And after that, they have to undergo a initial judicial training by the Judicial Academy. In 2014, also the Judicial Academy was submitted to the control of the government. There is a report that I prepared in this issue. So we don't have an independent training in Turkey. Now we even wonder whether a training exists, because this number, 10,000 people that have been recruited in a short time, it's almost impossible to organize a proper training for them and to check the capacity and qualities. And there is a recent report by the Council of Europe about the fact that even from the institution, even from the court, there is a lot of skepticism about the capacity of the new judges to exercise justice in Turkey, and they have to deal with really complicated cases because the case load has been inflated by this investigation, tens and thousands of investigation, and the cases take years to be brought in front of the court. Still, some people who have been arrested in July 2016 are still waiting for trial after almost 5 years. So, considering the overall situation, imagining judges or prosecutors who have the independence and the capacity to run against the interest of the state is very hard to consider. But apart from that, there is also the legislation. As I said, I mean, there is a big problem with the legislation. For what regards, for example, freedom of expression, there is a provision in the anti-terror law which provides that in case of publication of statement of criminal organization, the person who publishes the statement can be punished. So this is a news. This is not This is not a statement. It's a statement made by someone else, which is reported by the press. So the judge is even not requested to consider the context of the news, but only the fact that the news has been published. And if the prosecutor or the judge does not start an investigation or does not punish if it is the legislation, which is the consequence for him or her. Let me make another example. There is an article in the Criminal Code, which is Article 100, Paragraph 3, which is called the so-called Catalogue Crime, which is a list of criminal offenses. If one offense falls under the list, and basically all provision of the anti-terrorism law are included in the list, in order to issue a pre-trial detention order, it is not needed to a certain particular condition, whether there is a risk of fleeing, a risk of committing another offense, the risk of absconding the evidence. No, it is sufficient that the fact falls under the provision to issue a pre-trial detention order. And I had the opportunity to read many decisions, and basically I did not find a reasoning in the decision, but only the fact that the case falls under the umbrella of the Catalogue Crime. What happens to the judge who does not issue a detention order in this situation? So I see the situation very hard to be recovered in the current conditions.
Yeah, okay, thank you very much. Now I'm turning to Judge John Percy. Have you any question?
Thank you, Madam President. I think my question has been partly answered. I seem to get the impression that the vicissitudes in this matter of independence of judiciary and access to justice is somehow running in tandem with the efforts for Turkey to join the European Union. And am I hallucinating, Mr. Justice, or is there any kind of influence of one set of developments on the other? Or is it just a purely domestic issue, this kind of disintegration of the rule of law, really?
So
the
question is whether it is connected with the deterioration of the rule of law in Europe. This is the question, or what?
Almost. It is really linked to the process of Turkey's efforts to join the European Union and the lack of advancement therein.
Okay, this is a bit difficult question. What I can tell you is the following. I've followed many processes of negotiation for the accession to the European Union. I followed Croatia until the very end when it entered the European Union, Montenegro, Albania once or twice. And Turkey was the only country. First of all, the process in Turkey was very transparent, because it is the only country among the ones that I visited that published the report of the independent expert. Because it is up to the country which is visited to decide whether to make it public or not. So until 2013, 14, it was a very transparent process. And it was a real dialogue between European Union and Turkey. However, it was also the only country, maybe for its capacity to make researches and deep evaluation, that reacted to recommendation of the European Union, highlighting the deficiencies in European Union. For example, the High Judicial Council is not enough independent, okay, but there are countries in Europe which have not a Judicial Council. This is the reaction, for example, Germany or Austria. And every time it was a discussion of this kind. It was a transparent dialogue, but it's hardly to say if there was a real ownership of the reforms recommended by the European Union. There was a visible progress, but you don't know whether there was a proper ownership of the reforms. At a certain point, unfortunately, everything collapsed.
Thank you so much. That's most kind of you. Thank you.
Thank you very much. From the other side, just Bayens, would you like to put a question?
Thank you. I have a very specific question and then one that, it's a bit broader, I guess. But the first, the more specific question. If I understand correctly, most, if not all, of the dismissal of judges, dismissal, or actually charges and prosecutions against judges and prosecutors are based on the accusation of belonging to a terrorist organization. Is that correct, or are other
According
charges?
to my knowledge, for most of them is correct. This is my knowledge, but I'm here. I'm reading reports coming from Turkey, so it's not any visit to Turkey to.
Okay, no, thank you. Just wanted to see if there was another
This is
type of charge that was recurrent as well.
This is the FETO terrorist organization, the Gulenist terror organization. So the main accusation, not for everyone, is belonging. But sorry if I may add one point. So there are two parts that have to be considered. One is how to classify a terrorist organization, when we have a criminal organization or not, because this is the precondition in order to apply the anti-terrorism law. And secondly, we have the problem with the provision of the criminal code and the anti-terror law. Serious problem. Turkey has received recommendation along the years always to change this legislation. It has never been changed. Only along the fourth package of judicial reform in 2013, some punishment have been reduced for people who were serving the punishment, but it did not bring it to the change of the legal framework. If we look at the first point, what is a terrorist organization? At least a condition, according to the international law, is that this organization exerts violence. And we have cases in Turkey that people have been punished for terrorism being member or supporter of organizations which were not violent. And secondly, recently, we have another issue, which is not, but tomorrow morning might be the first testimony will speak about this. The fact that some people are charged with these charges because they are close to the HDP party, which is a party legally represented in the parliament. Why I'm telling this? This is not my opinion. There is an excellent report of the UK Home Office of 2019 displaying what is happening to the people who are connected with the HDP. So it's not only the PKK, let's say the Öcalan reference movement, but now apparently, according to this report of the UK Home Office, it's also the HDP, which is a target for this kind of charge. For judges and prosecutors, mostly is FETO, terrorist organization.
Thank you. If I may, the other question is, I was really struck by your and I can understand, the picture that is painted in your report, which is very, very good, I have only very good things to say about the quality of the report, is very bleak, it's terribly pessimistic, and there's a phrase in particular that it really struck to me when you mentioned the change in 2013, and you speak about an irreversible turning point for the protection of human rights in Turkey. And of course, there are many things that have happened that you cannot go back in time, like to return the situation to go back on the violations that have been committed, but can you elaborate a little bit more on that? Why the term irreversible? Okay,
of course, this is short time. I'm not thinking about the eternity, but this is short or middle time provision. What I'm thinking about? I'm thinking about the fact that the judiciary has changed completely in Turkey. So when 4,500 people have been dismissed and they are detained or refugees, a new 10,000, which means half of the judiciary, are recruited. And it is not clear what process has been followed in the recruitment. according to some institutional observers, there has been also politicization in the recruitment of the new judges and prosecutors. I wonder when it will be possible for this judiciary to regain independence, credibility, professional capacity. Of course, it is possible. Everything is possible as long as we are alive. But the short-term perspective is not encouraging. It might be that if a new judicial council or an independent institution is set up, these judges and prosecutors start to think independently. Who knows? It might be possible. But the perspective is not encouraging, at least for the short time.
Much. And you will have the last say.
Yes, actually, it is indeed not a question, Judge. I am very appreciative of this very good, solid report. I have no questions about it. I see the topic is both judicial independence and access to justice, and then you actually seem to deal with the fate of lawyers, disappearances and people who died and so on under the access to justice part, which I think is fine. I see your report differs a little bit from the other ones that started with an executive summary. You took the more dramatic route of a prologue and an epilogue, and the epilogue you combined with a conclusion. All I can say is it is, speaking for myself, highly depressing. I agree with you that, as far as I know, and based on some countries in Africa, for example, where I come from, it can take very long for the judiciary and for a legal system to recover. However, it is possible. And there are even on the African continents, there are examples of vetting and so forth and so forth. But of course, for that, the political will is required, a sincere, honest, genuine desire to have an independent judiciary and a fair legal system is required. So I am pessimistic at this stage, but let's hope for the future. Speaking for myself, I am prima facie persuaded by you, prima facie only. I am fully persuaded by you and by your conclusions. However, should the Turkish government bring us arguments and information to the opposite, should the witnesses tomorrow have something else to say, and should my colleagues persuade me, for which I'm open, I may change my view, but at this stage, I am in agreement with you on your conclusions. Thank you.
Thank you very much.
Thank you so much. Thank you.
So I think now we are at the end of the afternoon. Thank you very much again.